Okay, before the judge even finishes the charges, look at the tone here. This is the kind of courtroom energy where you know the judge has already read the file and is not in the mood for nonsense. Also, harassment charges, they're misdemeanors, but the real danger is what the behavior suggests, and that's exactly what this next section reveals. Mr. Johnson, you were charged. You were charged with harassment. You were facing up to 6.
Mr. Johnson, you were charged. Shh.
This is where things go from simple harassment to potentially something much more serious. Sending unsolicited explicit content, especially involving another person, isn't just creepy. It can cross into felony territory depending on the identity of the person in the video, consent, and distribution laws. Notice the judge and officer are confused here. That uncertainty is actually a big legal problem, because not knowing the identity of the person in the video creates a massive investigative gap. The video showed a female laying on her stomach, nude.
You were charged with harassment. You are facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you.
And judges, you know the details of this case are
Quiet.
just
Read it.
officer reviewed a police report from February 4th, 2025, after the officer spoke with the complainant. The complainant stated the defendant, her ex-boyfriend, called the complainant and stated that he was going to kill her and then showed up at her job. The defendant was approached by security and fled the scene prior to contacting the complainant. On February 24th, 2025, the defiant officer called the complainant. The complainant stated that on February 7th, 2025, she told the defendant via phone call to stop harassing her, and the defendant told her he did not give a fuck. On February 12th, 2025, the complainant received an email that stated, "Skip pussy bitch, I just love you." The defendant also sent a 20-second pornography video. The video showed a female laying on her stomach, nude, and the video zoomed in on the female's vagina, with fingers being used to spread the female's buttocks to expose the inside of her vagina. The complainant recognized the hand and the fingers in the video to belong to the defendant and recognized the room. The complainant stated the defendant had previously emailed her on March 16th, 2024 from the same email, sending a picture of himself at work. On February 18th, 2025, the defendant emailed the complainant 6 times. On February 23rd, 2025, the defendant emailed the complainant 9 times. On February 24th, 2025, the defendant emailed the complainant once. The complainant changed her phone number on February 22nd, 2025, because she kept getting phone calls from unknown numbers, and when she would answer, the call would hang up. The officer texted a photo of—
Quick check-in for you watching. Do you think these bond conditions are too strict, or exactly right for the circumstances? Let me know, because this judge is clearly drawing a hard line. The GPS monitor, no contact order, the smoke signals comment. This isn't just a warning. It's a step 1 toe out of line and you're done ultimatum. Judges only talk like this when they believe someone is a real risk. I'm ordering you as a condition of your bond not to consume alcohol.
of the defendant from his Texas driver's license, and the complainant identified the defendant.
Pornography video that was sent.
We don't know the ID of the female in the video.
So, Your Honor, I think it would probably take some more investigating to figure out the identity of that female. So we can't tell about it. I don't know if it's recognized her. But that is.
She would say whether she recognized it was her. I would imagine that there's a whole host.
That's a felony.
Yeah,
If it's.
we haven't spoken to her directly yet, Your Honor.
It's just because it's been in black badge.
Mr. Johnson, I'm going to find that there's sufficient probable cause to go forward with your case. I'm ordering you as a condition of your bond not to consume alcohol, illegal drugs, unprescribed controlled medication. I'm going to order you not to have any contact with the complaining witness. I'm going to put a GPS monitor on you so I know where you are at all times. If I find that you go anywhere near this person, if I find that you try to have any communication with this person through any means, I don't care what it is, if it's Snapchat, if it's Facebook, social media, smoke signals, whatever it is, I will put you in jail. I'm going to do everything in my power to protect my community at all costs. I don't care who you are. Do you understand?
Yes, sir.
I'm now entering into what's called a magistrate order for emergency protection. This is a court order that identifies Ms. Turner as a protected individual. You cannot commit family violence or an assault against this person. Commit an act in furtherance of an offense under section 42.072 of the Texas Penal Code, which is the stalking statute. You cannot threaten, harass, use another person to communicate a threat or harassing behavior. You cannot be in possession of a weapon or go within 200 feet of where she lives or where she works. If you violate this court order, the state can and will probably file a violation of protective order. It's one of the worst cases that you can pick up. Do you understand?
Yes, sir.
Okay, we need to talk about bond.
Your Honor, the defendant works for Enterprise. He's an IT specialist. He's been working there for over 5 years. And he's got ties here. He's been living in Houston for over 5 years. And he has child support for 3 children that he takes care of on the weekends. They're with the baby mom on the weekdays. But he does work, and he is working. And so we would ask that, and he's no threat. He's not shown any threat previously, and he does have strong ties. We were requesting a bond of $1,500. We have the bondsman here today who could cover that.
I would be unopposed to a bond of $1,500 if he were to have a GPS monitor with an exclusion code.
I'm
So-
gonna order.
Yeah, so I'm unopposed to that as long as he has the exclusion code.
So, Joe.
Bond will be set at the 1,500 then. You will get no more warnings, Mr. Johnson. You're in the free world now. Act accordingly. If I find that you do anything, it's not going to go well. Do you understand?
Yes, sir.
Okay, all right. So you have a bonding company here now?
He's speaking.
Okay. He'll have to meet with Michelle first for all the bond conditions. Then after that, we can release him to the bonding company.
He's at the objection.
Yeah, for sure. Okay. All right. Thanks, Joe.